Good afternoon, everyone, and welcome to the Alternative Dispute Resolution Certification Working Group. It is now 2:02 p.m. Pacific Time. Please remember that this meeting is being recorded. I am Judge Risa Pichon, and I am honored to chair this working group. I will provide a longer introduction momentarily, but before I do that, I will ask Angela if you'll please call the roll.
All right, I will take the roll. Armstrong.
Here.
Coulter.
Here.
Curtis. Dinkin.
Oh, I'm sorry. Curtis is here. Was on mute.
Thank you. Dinkin. Dubo.
Here.
Ellis.
Here.
Dr. Getz.
Here.
Higuchi.
Here.
Hodgson.
Here.
Jones.
Here.
Kelly.
Here.
Kopikin. Cruz.
Here.
Lowe.
Here.
Judge Lucky. Palesky.
Here.
Judge Pichon.
Here.
Robertson.
I'm here.
Tukman.
Here.
Welch.
Here.
And Yamshon.
Here.
Thank you.
Thank you, Angela. The next item on the agenda is typically public comment, followed by the chair report and the staff report. But as this is our very first meeting, we will begin with member and staff introductions, followed by public comment. For this meeting, there will be no chair or staff report. So we will move on to the business of the meeting. Next on the agenda is item 2.1. That's working group member and staff introductions. So that we can get to know each other, we'd like for each working group member to, in 3 minutes or less, and I emphasize or less, please share your name and how you would like to be addressed, your affiliation, if any, the nature of your work, one benefit of the certification program, and one concern about the program. So I will start. As I said, I am Judge Risa Pichon, and during the meetings, I would like to be called Judge Pichon. I am a neutral with JAMS, Judicial Arbitration and Mediation Services. I retired from the Santa Clara County Superior Court in 2019. My judicial career includes court commissioner, municipal court judge, and superior court judge. I was elected presiding judge of each court. I began working with JAMS a month after I retired, and I now work as a mediator and an arbitrator. I consider one benefit of the certification program will be consistency in the requirements for certification and the certification process, and its emphasis on minimum ethical standards that are necessary to become certified and to remain certified. One concern I have about the program relates to the establishment of tiers and how best to explain the requirements to be included in one versus another, and how best to explain their purpose and to ensure that they are not utilized by the public as an indicator of ability, expertise, or experience. So next I'll move to the vice chair, Dr. Getz.
Well, thank you very much. And I'm honored to be part of this group. And thank you all very much for listening to me for a couple minutes. I'll just be brief. Nature of my work, I'm a teacher, mediator, and arbitrator. And my affiliations, I currently have teaching assignments at University of Southern California Law School, Gould School of Law. I teach mediation and practice there. I also do a lot of work for the LA County Bar Association, the attorney-client fee mediation and arbitration that come up before them. I also do a lot of work for FINRA, the Financial Industry Regulatory Authority. I'm an arbitrator in that setting. In the past, I have been president. Many of you may know me as president of MC3, which was a nonprofit voluntary mediator certification organization. I served there for 9 years. And then also in the past, I developed the first online law school in the United States. It was called Concord Law School, and it's now run by Purdue University. The benefit of the certification program, those of you who know me, I obviously believe that mediation and arbitration are fields that deserve to be professionalized, deserve both from the practitioner standpoint and from the consumer standpoint. So I think we can be independent. Excuse me, is that it? I'm sorry, I thought I heard something. Okay, and that's and then the concern I would have would just be that we make sure whatever certification standards we come out of here with for arbitration mediators are in fact based upon their qualification and experience in those fields.
Thank you, Dr. Getz. Now, I was going to call everybody by looking at the screen because I didn't check who was here. So bear with me. I'm going to call out a name. If the person's not here, please just let me know. We'll start with Nolan Armstrong, and I did see him.
Thank you. Good afternoon, everybody. My name is Nolan Armstrong. Everybody's free to call me Nolan. I am a neutral with Signature Resolution, working out of the Oakland office. I joined Signature full-time in January of this year, so relatively new to the ADR world. Before joining Signature, I was a defense attorney for 20 years with the McNamara law firm in the East Bay. In terms of the benefits of the certification program, I see a benefit to consumers and in terms of the ability to select competent and qualified ADR providers, whether it's at the company level or individual providers. Potential barriers to entry, well, potential downsides would be barriers to entry potentially through the qualification standards that might be set. I've seen that with some of the court programs in the jurisdictions that I've practiced over the years. So, but look forward to serving on the group, and nice to meet everybody.
Thank you. Claudia Brown Coulter.
Thank you, Judge Pashan. Hi, I'm Claudia Brown Coulter. Please call me Claudia. I am the current president of the Southern California Mediation Association. I practice family law, so I do a lot of divorce. I'm also a legal document assistant. That means that I am not an attorney. I spent 21 years as a public school teacher, and during that time, I went to the Strauss Institute at Pepperdine Law to earn my master's in dispute resolution. So one of the benefits I see of this certification program, if done correctly, can really promote the profession of mediation, because consumers are still not really aware of what it is, and it can also help protect the consumer from rogue mediators, for lack of a better term, who actually aren't qualified, who haven't done the education, don't maybe know what they're doing. One concern about the program is making sure that the price point for entry for non-attorney mediators is not prohibited. I know that this committee is going to do a great job to protect the interest of all mediators, and I'm looking forward to working with you all. Thank you, Judge.
Okay, thank you, Claudia. Dana Curtis.
Yes, thank you, Judge. I'm Dana Curtis. I like to be called Dana. I'm a mediator in private practice with my own practice, Dana Curtis Mediation in the Bay Area. I began my mediation career full-time in 1991. And before that, I practiced employment and commercial litigation. And before that, I was a public school teacher for 13 years. So that's right. The thread of my practice really, the thread of my teaching goes throughout my entire life, really. And so in addition to being a mediator since 1991, I've been a teacher of mediation, both in the academic context at Stanford Law School for 10 years and Santa Clara for 10 years. I also directed the Santa Clara's dispute resolution program for a number of years as well. And I've taught mediation in many contexts, but scores of court-connected cases. I've trained mediators, and I worked with Gary Friedman and Bob Manukin at Harvard in their program in negotiation, teaching mediating disputes for 9 years. I think the advantage of having a certification program is to have a way of really demonstrating to the public that they can have confidence that mediators who have been certified meet a minimum requirement. And so, and so public confidence, I'd like to think that protecting the public is one of those, because if there's a way that mediators who haven't, or the parties don't think that they've performed as they should, there's a complaint procedure. And that's, in a minute, one of the questions that I have. But I also think there's a benefit to providers. And having taught ethics as part of all of the courses that I've taught, I'm surprised that people who've been mediating for a long time haven't really had ethical standards at top of mind. And so it's always great fun to work with people and see the light bulbs go off. So if we have a very serious commitment as people who are certified to these standards of conduct and the procedures, I think it can, heighten the level of practice for all of us. So one concern is how do we provide a consistent and how do we provide a consistent way of allowing for complaints and investigating complaints when we come from so many different practices? And, the most immediate one is the solo practitioner versus the provider. So anyway, I look forward to addressing all of these things with all of you, and thank you.
Thank you, Dana. Stephen Dinkin. Okay, Paul DeBow. Jenna Ellis.
Thank you, Your Honor. My name is Jenna Ellis. You can call me Jenna. I am the Director of Legal Services at Judicate West. My work involves a couple different hats, but one of them is to serve in a corporate counsel type role for the company. But I also consider myself an educator. One thing I love to do is educate, support neutrals and staff regarding the ins and outs of different ADR processes, including when it comes to things like ethics standards for arbitrators. A benefit of the certification program, this echoes some comments made already, but to quote from our new code section, I do hope it brings a higher level of commitment to accountability and consumer protection. A concern about the program, to echo a comment from one of our public comments, I do hope that it allows us to provide far-reaching education to consumers. Thank you.
Thank you.
I'm Paul Dubois, and
Yes. Yes.
I'm sorry, I skipped before. Call me Paul, and I'm a AAA arbitrator and mediator. I do most of my cases are either employment law or ERISA withdrawal liability, but I do other things as well. I've been a full-time neutral since 2001. I began part-time beginning in 1994. I am also on the board of the California Dispute Resolution Council, and I am their legislative chair. I was also involved in the creation of the court-connected mediation program, and I'm also a member of the College of Commercial Arbitrators. One benefit of the certificate program, I think, is that it will enable the public to understand that some people have had some kind of training or done something that assures them of our integrity and ability to perform the work. But I have 4 concerns. One is the tier program. I don't know how that's going to turn out. A second one is barriers to entry, concerned about that. On the other side of the coin, I am concerned that if we just have a program where you promise to have a complaint procedure, et cetera, and nothing more, anybody can start out and day one become certified, and hope that does not occur. And the last one that I'm concerned about, and probably the one that's the highest in my mind, is I'm very concerned about the complaint procedure and its effect on the confidentiality section of the evidence code with respect to mediation. And I'm looking forward to working with all of you on this panel.
Okay, thank you. And I'm sure you said how you'd like to be called, and I probably missed it.
What's that?
I missed how you would like to be called.
Oh, sorry, Paul.
Okay, all right, thank you, Paul. All right, Dario Higuchi.
Yep. Hi, thank you. My name is Dario Higuchi. Please call me Dario. I am one of the founders of a mediation firm called Signature Resolution. My work mostly is recruiting, alongside probably guiding the direction of the firm, but mostly recruiting. I think the biggest benefit is the increasing public awareness and public confidence on the process, helping the consumers understand what the ADR world is. And one concern, I didn't really have a concern at first, but I share a few of the concerns brought up by the colleagues. But I think one of them is the barriers to entry. I think that may be an issue, or not. But initially, when I first started learning about this whole certification, it didn't bother me, or it didn't occur to me of any concern, didn't bring up any concern right away. So,
Okay. Oh, go ahead.
thank you. That's it. Thank you so much.
Oh, okay. Thank you, Dario. So I believe we have a guest who has arrived, and I believe Senator Tom Umberg is here. He is the author of SB 90, and he would like to make a few remarks. Senator Umberg?
I believe, Senator Umberg, is that you listed as Thomas's iPhone?
There we go.
Oh, okay.
So thank you. Well, thank you for the invitation. Thank you for including me. I heard a few of the comments here, and that is sort of the vision of providing the State Bar an opportunity to create a process for certification. It's now in your hands. What I wanted to do was I wanted to create a certification program, not mandatory, but such that consumers in the marketplace could see that certain individuals or certain firms have met ethical standards or other standards that you will set, and that we do so in a way that we maintain and maybe in some cases restore integrity to the process. Because this will apply to both lawyers and non-lawyers in terms of any sort of enforcement, I only envision that the key enforcement mechanism is either certification or decertification. Of course, if a lawyer engages in conduct as a mediator, arbitrator that is violative of the canon of ethics, then of course the bar might take independent action. So I'm leaving it in your hands. I'm carrying the bar bill this year. And so if there's a modification that you would suggest in terms of the law that provides you the opportunity to set those standards, I'm interested in hearing about it. And with that, thank you.
Thank you, Senator Umberg. We appreciate your comments. All right, I see. I see Executive Director Leah Wilson in the squares. Hello. Would you like to make a few remarks?
Sure, just introduce myself, Leah Wilson, the Executive Director of the State Bar. And as you heard from Senator Umberg, who's the motivating drive behind this initiative, we are really welcoming the responsibility and the opportunity to work with all of you to create a first of its kind certification framework in California. It's been really interesting hearing the diverse backgrounds that each of you are bringing to this work. And I know Erica has emphasized to me how complex your task is, given the significant diversity in the types and structures of providers that there are. So it sounds like you're the group to meet the task. And I just want to share with you that our lead staff on this, Erica Doherty, we have tremendous confidence in her. She's newly been elevated to the role of Deputy Executive Director at the State Bar. So you're in excellent hands. So thank you so much for your work. And as I will be joining in just in listening mode in these meetings and helping to make sure you have the resources you need to do your work. So thank you again.
Thank you so much, Ms. Wilson. All right, we'll go back to the group, and I think the PowerPoint the sharing screen might be necessary so no one forgets what they might want to say. But next is Sarah Hodgkin.
Hi, everyone. My name is Sarah Hodson, and I would like to be addressed as Sarah. I am with the Riverside Superior Court. I am currently the court's general counsel. Before becoming general counsel, I was the court's managing attorney for alternative dispute resolution programs. I was in that role for approximately 9 years. In my current role, I supervise the current court ADR director. I am also a member of the Judicial Council's Civil and Small Claims Advisory Committee. And in that capacity, I serve as the chair of that advisory committee's ADR subcommittee. One benefit that I think for the certification program is the potential for consistency in requirements and ethics and how we handle complaints for ADR providers, which may lend greater legitimacy and trustworthiness for the public when they are seeking out ADR providers. One concern I have is to ensure that we find a sweet spot between making sure that those requirements lend the legitimacy, but aren't so difficult to achieve that no one is able to reach them, and particularly that they are not so difficult to achieve that we aren't getting a diverse number of people and organizations, including non-attorney ADR providers, participating in the certification. Thank you.
Thank you, Sarah. Katie Jones.
Thank you. Hello, everybody. My name is Katie Jones. I'd like to be referred to as Katie, please. I work at ADR Services, Inc., based in Northern California. I'm a marketing production manager, so I'm on the administrative and marketing side of things. This includes running our in-house CLE program, so I'm very versed in the legal ethics side of things, putting those presentations together. Additionally, I'm heavily involved in the case management side of things, so facilitating all of the administration in mediation, arbitration, and private judging. I see a benefit of the certification program as, really standardizing expectations and maintaining the high caliber of service that providers and mediators can hold themselves to. So I think that's really useful to establish metrics. But a concern I do have is finding the balance between oversight and transparency with the flexibility and agile response that mediation currently offers, especially on the administrative side, to allow people to really access quick and efficient resolution that attorneys and parties alike have come to expect from the alternative dispute resolution.
Thank you, Katie. Ron Kelly.
Good afternoon, everybody. Please call me Ron. I'm here just representing myself, but I'll list a few of my prior affiliations. I've been on the American Arbitration Association's panel of arbitrators since the mid-'80s, which is when I started my professional practice of mediation and arbitration. I became full-time in 1991. I was a founder of the California Dispute Resolution Council and I've been a member ever since. The nature of my work has been professionally mediating and arbitrating, primarily breach of contract, a lot of real estate, construction, that sort of thing, business disputes. But the nature of my work has also been in trying to shape the laws and the court rules in California. I initiated and guided the formation of the Evidence Code chapter, sections 1115 through 1129 now, back in the mid-90s, and have played an active role in most of the pieces of legislation around mediation that have happened since then. Back to affiliations, I have worked with hundreds of groups in organizing lobbying campaigns on that score. One benefit I really see that's potential here is that mediators who have not been required, unless they were court-connected mediators, to comply with the really excellent set of rules of court will need to do so if they want to be certified. And I'll just say that this committee is really fortunate to have Alan Weiner as staff, who I know played a very central role in drafting the rules of court, and I know will be a major benefit to this working group as we go forward. One concern I have about the program, my central concern, as it's been for 30 years, is making sure that people in mediation can speak honestly to one another and to the mediator without concern that their communications might later be used against them or against anyone in the process without their consent. And Madam Chair, I'd like to make a motion when we're done with the introductions that's relevant to this agenda item. Thank you.
Oh, okay, thank you. Jill Kopagan?
Hi, I am Jill Kopaken. Excellent job, Your Honor, in pronouncing my name. Thank you.
I looked it up. I
Okay.
looked it up, so I get it right.
Yeah, I'm impressed. You can call me Jill, and my current affiliation is as the program director for the Northern District of California's ADR program. Historically, I have been involved in, I'm a reformed litigator of 30 plus years, but I have been involved in all different kinds of alternative dispute resolution, including, mandatory settlement conferences, as well as community mediation and things like that. Through those different lenses on ADR, I think that some of the benefits I see include the democratization to bring into the tent some of those folks who are not the traditional lawyer mediators and bring skills that I think are often underlooked in mediation. But along with some of the other folks who said this today, I think Dana said it, the idea that we would ensure a certain level of ethics exposure and training, as well as other skills training, I think is really important. I think that would be a benefit. Some of my concerns have already been touched upon, but just briefly, one, the confidentiality issue is huge. I think that's something we really need to be mindful of. The other barriers to entry that were discussed, I guess there are two kinds that I can think of. One is people who are in larger organizations who providing ADR services may have the framework to provide things like the complaint procedures. It may be more difficult for smaller practitioners. That can have a barrier to entry for the practitioner, as well as potentially raising costs as a barrier to entry for consumers, and that's a big concern. I guess the final concern may be somewhat unique to me as the administrator of a court program, but I have some concerns about, a lot of concerns actually, about the disclosure requirements in terms of aligning with the arbitration rules, and that this could put a burden on people who are providing mediation services, which to me are qualitatively different than arbitration, in that there is no, authority to make decisions. And so the disclosure requirements that I see very sensible in the arbitration context could be very onerous in the mediation context in particular, and that could have a chilling effect on the ability for things like court programs to be able to provide those services, because we would have difficulty getting people to volunteer on a pro bono basis if it would, affect their ability to provide certain services. So I have concerns there on a sort of access to justice kind of issue. And I can articulate that further at some later time, but just want to put a pin in that issue. It's one that hasn't been raised. Thank you.
All right, thank you, Jill. Diana Cruz.
Hi, everyone. Please call me Diana. I'm affiliated with several of the groups that are also members of this working group. So I'm a AAA arbitrator and a mediator and arbitrator with Judicate West. I'm also the current chair of the California Lawyers Association ADR committee, as well as a board member of several other ADR oriented committees, such as the CDRC and the AAA Women's Resource Group. Before becoming a full-time neutral, I was everything from a paralegal to a partner at a big firm. I clerked at the Northern District of California, hi Jill, and also served as a judicial officer for a while as a Superior Court commissioner. So I've sort of seen the levels of the law in a multifaceted way. I am excited about the certification program, but also have concerns. I echo Sarah's very well thought out potential benefits and hope that we're able to accomplish two primary goals: simplicity and transparency, because I think both of them are going to guide me in the comments that I make in this group. With respect to concerns, I again echo Ron's concerns, Paul's concerns, and Jill, the concerns you noticed. My primary one when I first started getting involved with this statute was the potential adverse impact that this certification process could have on young neutrals, diverse neutrals, and also neutrals who are unaffiliated with many of the big providers or large organizations. And so I think it's very, very important that we think about that carefully and protect those interests while also, serving the consumer goals that were behind implementation of the statute. I'm really looking forward to working with you all, many of whom I know already. And for those who don't know me, I can't wait to get to know you better. Thanks.
Thank you, Diana. Kimberly Lowe.
Thank you. My name is Kimberly Lowe, and you can please feel free to call me Kim. I am Senior Counsel Legal Affairs with JAMS. Prior to joining JAMS, I was a litigator. I think I heard somebody else say a recovering litigator or something along those lines, but now I work in the ADR space. I think I'm going to end up echoing what a lot of the prior members have said with regard to the benefit of the certification program. I see, the goal of ensuring that arbitrators and mediators are reaching these high standards of competence and ethics and professionalism, and in trying to find a way to ensure that all are adhering and complying to those ethics standards that California does have, which are very high and some of the, the best that we have in the country. And I do echo the concerns with regard to the tiers of the program. While it may be easier for a larger provider like JAMS to reach the higher tier, I do see some barriers to entry to those that may not be affiliated with, a provider such as ours, and also the confidentiality piece when it comes to mediations and what mediators are required to do. I think that's really important for us to focus on.
Thank you, Kim. Judge Jackson Lucky.
Hi, I'm Jack Lucky. I prefer Jack or Jackson. I don't have a real preference as to either. I don't prefer Judge, but people seem to be unable to call me anything but. I'm currently with JAMS. I have been here for about 3.5 years. I have a general practice, including general civil and family cases. I also do arbitrations and private judging. I think I can't say anything new about benefits or concerns, but I will just emphasize some of the concerns as a judge who used to run I'm going to say, direct-to-consumer ADR programs for family law litigants in my court before I retired. I do see the potential for barriers to entry for, I think, our most needy our most needy litigants. And so I think that concerns me. The B2B type mediations and arbitrations that I think JAMS and ADR Services and Judicate West and Signature provide, the larger providers, are not going to have as many barriers because they have that institutional backing. And so I think the more we can concentrate on the impact that it has for the little person and access to justice, the better. Thank you.
Thank you, Judge Lucky. Next is Cliff Palevsky.
Well, thank you. Yeah, please call me Cliff. I was asked to participate by Senator Umberg's staff. Happy to. I am I am a practicing unreformed civil rights and employment lawyer, but I don't think there's anybody on the panel who believes more in the benefits and promise of ADR than I do. I brought the concept of mediation to the plaintiffs bar in '92. I've been involved in drafting most of the California legislation, a lot of the ethics rules, participating with the Judicial Council since about 2002. I've argued 7 cases to the California Supreme Court on arbitration and many others, including up to the United States Supreme Court. I really think I'm here to protect the public. I want ADR to succeed. My biggest concern, well, I've got a few concerns, but my biggest concern is that I know that the most important factor in making ADR fair and perceived as fair is consent and voluntariness. And unfortunately, we're not going to be able to take that on in light of certain judicial opinions. So I think our work is sort of cut out for us to address the financial realities, the financial considerations. I think one of the biggest holes, and this was a concern I expressed when I heard about this, is that we presently have a decent set of ethical rules for arbitrators, and I consider them mandatory. So I wasn't really sure what the benefit of saying I comply with mandatory ethical rules is. We need to have a meaningful set of ethical rules for the first time for providers. And obviously, mediation and arbitration are under the rubric of ADR. They're completely different processes. I think mediation is working fairly well. I think the cost has gotten a bit out of control for anyone who cares about access to justice, but I still think mediation is a great process. Arbitration, especially because of the lack of consent, is where ADR is taking a beating, appropriately so, in perception and in the reality. I am often critical of some of the providers. I acknowledge that AAA and JAMS do the best and do try, but I do think that there are realities when you have corporations and financial considerations that are present in the arbitration world, not as much in the mediation world. So I think we must take this opportunity to develop a meaningful set of ethical standards for providers, because they play such an important role in the selection of the arbitrators, the rules, the marketing, and in the perception of ADR in general. I think the Judicial Council rules need to be enhanced and updated, but we need to create, probably 20 years ago, there was an effort to create ethical rules by the Georgetown University and CPR for providers. People said yes, then they said no, and they've never seen the light of day. And unless we create meaningful ethical rules, this is just going to be a bunch of, how to file complaints. And I think we can do better than that. So that's where I'm coming from.
Thank you, Cliff. Maddie Robertson.
Hello, thank you all. I'm Maddie Robertson. You can call me Maddie. I am currently a professor of practice at UC Law San Francisco, formerly Hastings. We had our name change. You might not recognize our new name. I currently teach in a full-time role. So I teach in our mediation clinic where we are training and supervising students who work as mediators in real cases. And so I come from practice and not just academics, but I guess I am bringing our academic perspective to the committee. But I also have a lot of experience, many years running mediation and arbitration programs, training professional mediators, managing panels of neutrals, doing, direct service myself. I worked in the courts, I worked in nonprofits doing community work, so a variety of settings and cases. I have sat on quite a number of committees related to dispute resolution. I'm currently on the Association of American Law Schools Clinical ADR Committee, and I'm on the committee at the Alameda County Superior Court. So I'm still sort of plugged into the local courts. Also on the Mediation Society, I know we have at least a couple other members here. I interviewed Senator Umberg recently, so some of you may recognize me from that particular interview about this bill. I'm also a mediator. I take limited cases. I'm on the panel at the Northern District with Jill, so I take some of those cases. I also teach other practitioner trainings on various dispute resolution topics. And a benefit I see, I agree about having more visibility for mediation as a profession, right? Some people don't even know the word mediation is. They think it's meditation, and really raising that up as an option for professionals and for people who want to resolve their disputes without going through the courts or other ways. And concerns, definitely agree on the confidentiality issue. I think that's really important. I am also concerned about access to justice and the stakeholders here that we're really thinking about. So what about those solo practitioners, and what about nonprofits or others who run volunteer panels and the impact on those? And we have an issue with diversity in the profession, and I want to make sure people still have the ability to join this profession if they want to without too stringent requirements. So I'm hoping that we can have those values, like thinking of the stakeholders and access justice and all these other things that people have raised. I hope we can hang on to those values as we move forward. And one other concern is I really hope that we have a process that can be practical, right? Accessible to people, responsive to change. So I hope that there is transparency and data collection so that as things move along, we'd have the ability to shift and change those processes and tiers and programs and everything to make it better over time as well.
Thank you, Maddie. Thank you. Thank you. Stephen Dinkin.
Yes, my name's Steve Dinkin. You can call me Steve. I'm the president of the National Conflict Resolution Center based in San Diego. I've been in this role for over 20 years and have been on a number of different committees with a number of folks who are on this call today. Our organization has been around since the early 80s. We have done a tremendous amount of training of mediators over the past 40 years. We have a mediation panel called the West Coast Resolution Group. We also continue to do community mediation. So really a broad array as an organization. I think that's one of the concerns I'd say is that our organization represents a broad array of services, and California being such a large state, ADR, so many different permutations of that. How can this all fit under one tent and meet the needs of all the different types of providers? So I think that's something we'll really need to pay attention to. But the benefit in the end is confidence of the consumer. And I think a number of us have said that today, and that will be, a great accomplishment if we can come to a consensus on that and build in that confidence that's so needed in our field.
Thank you, Stephen. Eric Tuchman.
Thank you very much. I'm Eric Tuchman. I'm Executive Vice President and Chief Legal Officer at the American Arbitration Association. You can call me Eric. The nature of my work, in the nature of my work, I should say, I deal with a fair number of cases where there might be an allegation of perhaps misconduct or concerns raised, and even if they're not to the level that might give rise to a litigation, but they nonetheless give rise to concerns that a party's expressed. So over the years, I've seen a fair number of issues, seeing where they come from, what, as I say, gives rise to them. And I think a lot of that will be interesting to see how it interplays with the work that we're all going to be doing. I've also started in my early years, actually. I was involved as the AAA's representative on the AAA ABA-ACR Model Standards of Conduct for Mediators, and actually a little bit of the tail end of the redrafting of the Code of Ethics for Arbitrators. So I've got a little bit of insight from those projects as well. Things that I am optimistic about, or I think the benefits of this program, include that these are processes, arbitration mediation, that really they're intended to be, the promises, a more effective way of resolving disputes. And so if we can create a process, a procedure, or a certification program that is going to give parties, give the process greater credibility in the eyes of the parties, I think that is valued. In light of some of the criticisms that are taking place right now with respect to arbitration mediation, I think the things that I'm perhaps concerned about, they've all been expressed. I am also concerned about confidentiality. I would also say, again, we don't want to create standards that I think are going to unnecessarily give rise to additional claims or claims of liability to arbitrators and mediators. But the other issue that's become very apparent is that these standards really are going to have to apply to a tremendously wide range of practice areas. And they do have some different needs. So I would add that as a little bit of a concern as well. And looking forward to working with everybody. Thank you.
Thank you, Eric. Christopher Welch.
Thank you, Your Honor. It's a pleasure to be here with everyone. You all are extremely respected in the field, and just to be a part of the conversation is an honor in itself. I'm with the Center for Conflict Resolution. It's a nonprofit out of Los Angeles County. We have it's a dispute resolution provider in the court system in Los Angeles County, and I've been here for 21 years. I'm a non-attorney mediator since I got my master's in dispute resolution at Pepperdine University. And so there are multiple interests that come into play. For the past 9 years, I've worked with Dr. Getz and with Alan Wiener in the MC3 in the certification space, being on the board and trying to work through some of these certification issues for individuals. And so with that, we've been sitting with this for quite some time. But to see it at this state and to absolutely see the breadth at which we're trying to deal with these issues at the state level is going to be one that I think we're all up to the task, but it is going to be one we have to look out for a lot of things. For my the benefit, I mean, it's professionalism. To be at the table as a non-attorney mediator, to potentially be to raise a standard or to be in a space that might be available, that's amazing. And I think that that could be a benefit that's professionalized throughout, and those ethical standards, and to have that standard for the consumer, I think is extremely valuable and needed in both the mediation and arbitration space. I think for concerns about the program, I think if I'm taking my hat as a DERPA provider that uses volunteers trying to serve small claims, civil harassment, and UD cases, I mean, really looking on where does that sit with the certification standards, and if it's a tier, or how does that operate just functionally? How do we access to justice, even access just for mediators to get into the field? What does that look like? And finding pathways for those individuals or beyond, I think is just important. And so I will kind of wear those hats in some of those contexts. But thank you all very much. I'm excited to be a part of this panel and look forward to all of it. Thank you, Your Honor.
Thank you, Christopher. Daniel Yamshan. I know I didn't pronounce that right.
Oh, that's all right. I've been called much worse things, believe me.
Good afternoon, everyone. I apologize for not running my video. I'm in a rural area without broadband, and I have to use a hotspot. So if I use video, it becomes unstable. Anyway, I'm Daniel Yamshan. Please call me Daniel. I have been appointed to panels of the usual suspects that many of the others in this group have been, in addition to the Federal Deposit Insurance Corporation, and the United Nations Global Arbitrators List. I'm also on the roster of eminent and qualified experts in conflict prevention and post-conflict peace building for the UN. I started mediating in 1987, arbitrating in 1989, and became a full-time neutral in 1994. Most of my work is involved in construction and contracts and some international disputes. The Trans-Pacific disputes usually involve import-export issues, contract compliance with the bills of lading, quality of the work, etc. And the transatlantic cases involve usually conflicts between investment banks and the various exchanges in the various European capitals. Excuse me. I've been involved in program development and training, as well as a neutral in 15 countries on 5 continents. A lot of the work has been funded by various subdivisions of the State Department, the United Nations Development Program, the American Bar Association Rule of Law Initiative, and the World Bank. I think one of the major benefits of the program is that it actually involves practitioners and neutrals and organizations. Bismarck said that anyone who loves law or sausages should watch neither being made. And I had a high school civics teacher who said, beware of any legislation labeled as reform. So the fact that the legislature could have just kind of come in with an iron fist and a velvet glove, but instead turned it over to the ADR community, I think speaks well. And I'm very pleased about that, regardless of what you think of the necessity of the legislation. And I understand there's controversy in the ADR community about that. One of my concerns reflects somewhat what Christopher was talking about, was there is a potential, I think, for something of a conflict between other legislation, the Dispute Resolution Programs Act, which sets out training requirements and some other requirements for community mediators. And I think we'll find out about that as we dig deeper into our work. But I think that we need to take special care about non-lawyer neutrals. And there's many great mediators and arbitrators who do not have legal backgrounds. So I think that that is something that we need to keep in the back of our minds as we progress through the process. And thank you. And that's it.
Okay, thank you. Thank you, Daniel.
You're welcome.
Next would be Erica Doherty.
Thank you, Judge Pichon. Hi, everyone. I feel like I know all of you from email alone, but I'm Erica Doherty. I am the Deputy Executive Director of the State Bar of California. A little bit of background on me. I was recently the Program Director of the State Bar's Office of Professional Competence, which handles development of professional responsibility rules for lawyers in California, as well as proactive education to keep lawyers essentially out of the discipline system. At the State Bar, I've also worked in our Office of General Counsel and within our State Bar Court, and I was also an attorney to the Supreme Court's Committee on Judicial Ethics Opinions. I will say that I think a benefit of the certification program is to have some sort of standardized framework for ethical standards within ADR in perhaps pockets for different things, as this group has already alluded to and we'll be discussing later on in the business section of our agenda, as well as the transparency for consumers and for providers related to providers and practitioners who choose to be certified here. I think I have two concerns, if that's allowed. One is to address all of your concerns and the concerns of those who the certification framework will impact. There are many people who wanted to be able to be on this working group who cannot, just based on size. And then there are obviously, you know, the mediators, arbitrators, and so forth who will be impacted, and of course, the users of those services. I would be remiss to say that as staff, my personal biggest concern is actual implementation of this certification framework that is recommended by this working group. But I'm really looking forward to working with you all, and it's wonderful to see all of you here today.
Thank you so much, Erica. Alan Weiner.
Good afternoon, everyone. My name is Alan Weiner. I would appreciate you calling me Alan. I also appreciate your invitation to informality of using your first names. I do feel like this is a public hearing and they're members of the public and it's being recorded. And so I'm going to endeavor to refer to you by your surnames, as awkward as that may be with some of you whom I've known for 25 years. So please excuse me for that. My current affiliation is with the California State Bar as an attorney. I was grateful to be hired as a part-time temporary employee to help with the implementation of this program. And that is the extent of my responsibility with the State Bar. The nature of my work, I practiced law heavily in civil litigation for about 20 years. I returned to law school at Pepperdine to pursue degrees in alternative dispute resolution. After 20 years, I thought I'd be getting away from the courts, but found myself working for the courts, both for the California Judicial Council and for the Judicial Council of Maryland, both of those positions devoted to promoting the availability, quality, and use of ADR. There hasn't been a benefit of the certification program that any of you have mentioned or concern about the program that I do not share. I think all of those are important. I would just add that I think that this group, after hearing all of your introductions, you know, is very well comprised and up to the task of addressing the concerns and realizing the benefits. So thank you for participating.
Thank you very much, Alan. That completes the introductions. And before we move on to the next item, Ron Kelly, you said that you had a motion. I just am a little concerned that it's not agendized, but why don't you state what it is?
Well, I think it's directly relevant to this particular agenda item. We had a public comment from the American Association of Matrimonial Lawyers that we all got beforehand. And Ms. Doherty and Mr. Weiner could say whether or not they accurately perceived that none of the panel members were practitioners who were in divorce and family custody practice. And as all of you, I suspect, know, for 40 years, every divorcing set of parents with minor children has been required by law to mediate. It's probably the largest sector where mediation is required by law. And if they're correct, and Ms. Doherty and Mr. Weiner reviewed everyone's CVs, so I don't know if that's true, but based on these introductions, there are no practitioners who are mediators in divorce and family custody who, quite contrary to the kind of stuff I do, they get divorcing parents directly in joint session, trying to achieve enough understanding and reconciliation for the benefit of the minor children. And that's the state's main concern. So my motion would be, if that's an accurate statement, that the working group request the State Bar Executive Committee immediately expand this membership by 1 or 2 people, and with staff's recommendations, include that very huge sector of mediation in California. Thank you for the opportunity to make that motion.
Oh, certainly, Ron. And I hope that you don't mind waiting on that just a little bit until we go through the public comments, because that is what is next.
Thank you, Madam Chair.
So next on the agenda is the call for public. We have already received written public comment that was distributed to the working group in advance of this meeting, and it will be considered as part of business item 2.5. For those of you who wish to give public comment, the State Bar staff will first call on those who signed up in advance and then call on members of the public in the order that they appear in the pool. And I'll turn now to Angela.
Okay, for those who are participating by Zoom, please use the raise hand function at the bottom center of your screen right now to address the committee, and we will call you in the order that your hands are raised. If you're calling by phone, you can virtually raise your hand by pressing *9. We will allow 2 minutes for each speaker, up to 30 minutes in total. The on-screen timer will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. So if you would like to make a public comment, please use the raise hand function at this time.
Okay, and Angela, can you hear me?
Yes, I can.
I just wanted to apologize because I wanted to ask you to do your introduction and I neglected to do that. So
that is okay. Well, sure. Quickly, my name is Angela. I'm the person behind all the emails. I currently work in the Office of Professional Competence, doing administrative coordination for the Committee on Professional Responsibility and Conduct. So I'll be offering similar assistance to this working group, and I'm really looking forward to it. Thank you.
I'm sorry.
Okay, so first we have permanency planning mediation. I'll start the timer when you begin your comment. You can go ahead.
Hello there, my name is Cordell Wesselink. I didn't know how to change my name. I'm with Consortium for Children. We do permanency planning mediation within the child welfare system. So we're helping families figure out what kind of contact kids can have that are going through the child dependency system with their birth family after adoption. So it's a little bit different than custody or divorce, but we're working with families in sensitive areas. And yeah, thank you for taking my comment. I just want to echo a lot of the concerns and benefits that I've heard from the panel, and want to kind of say a couple, kind of reify some of that I heard, and the couple that I was thinking of before that I've also heard from some of the panel. One is around equity. And I'm glad that I see Christopher Welsh, and I also know Maddie are involved in community mediation. I have worked with community boards in San Francisco. I was their ADR programs director for 5 or 6 years before coming here. I've been in mediation for about 15 years now, since 2010. And yeah, I really want to make sure that there is a place for volunteer mediators, like to make sure that it's not going to price them out, that suddenly there's this cost for people volunteering, wanting to help their neighbors, that I've seen be very successful in neighbors helping neighbors. And suddenly now there's a certification program where will it make your neighbor not trust your neighbor because they're not certified, but they just can't afford to or don't want to, sell out the cost for being certified. So that's one concern. And then the next is accessibility, which I've heard from some panel members as far as accessibility to justice, and accessibility for the public, because I could see this raising costs for the public as well. So those are kind of my concerns, and I'm glad that you panel have brought those up, and I hope that you will consider those, and look forward to hearing how this goes. That is me. Thank you very much.
Thank you. Are there any other people who wish to give public comment? Please use the raise hand function. Okay, seeing none, I'll turn it back to you, Judge Bouchon.
Oh, okay, thank you. So, Ron, we've heard the public comments, and so I wonder if you want to just make your remarks part of your request, or do you want that to come from the entire group?
I'd like that to be a formal motion. I think the group is the kind of voice that maybe the Board of Trustees would listen to as opposed to one lone member. And I know it's been tough to try and select this group, and there's other groups that would be left out, but to me, the family and child custody sector is so huge. If the public comment we got in writing is accurate, and I believe it is, having heard the introductions, I think I'd like to make again that motion that this group requests the Board of Trustees expand the membership to have at least one participant, ideally two, from that sector. That's my motion. Thank you.
All right, you're welcome. And I'd like to get some input from Erica regarding process.
Yeah, two things. One, Chair, or Judge Pichon, excuse me, I apologize. Two things. One, I believe there was one more person who raised their hand to give public comment. Attendee Bob Murray, you had your hand raised. Did you intend to give public comment? It looks like we may have missed you at the last moment. If so, could you please raise your hand? Okay, he has indicated that, so if you would allow for him to give comment as well, and then we can turn, I'm sorry, Mr. Kelly, to your motion.
Oh, absolutely.
Okay, so Angela, can you invite Mr. Murray?
Yes, Bob Murray, you may start your comment when you're ready.
Yes, thank you, Erica, and thank you, Judge Pichon. Bob Murray is my name. I operate the Arbitration Mediation Center in Santa Rosa and have since 1993. And before that, litigated actively in civil matters. And in that text, did a lot of mediations. And one of the concerns I've got is I also operate, there's a small panel in Santa Rosa. And the concern I have on the confidentiality, in and of itself, it's a concern, but how will complaints be investigated and what process will ensure some sort of due process, not only for the attorneys involved, but the mediator, depending upon the nature of the complaint. So that is more of a drill down on confidentiality. And then in the overall certification process, and I do embrace the notion of professionalism, trained mediators, a proper skill set to help the public. But one concern I've got is there are clearly different styles of mediation, and a different style of a mediator could be, it seems to me, broadly interpreted as something that's not professional. So I'm just curious on how the group and how this certification will honor that, the styles as well as the due process of the participants. Thank you.
Yeah.
Thank you, Mr. Murray. All right, now I'm going to turn to Erica Doherty.
Thank you, Judge Pichon. So Ron, thank you for your motion. I would like to first, I thought that I had heard at least one, but perhaps more individuals indicate that they did have some family law, I feel like I'm at the Oscars, experience in one way, shape, or form. So perhaps maybe like if a quick show of hands, if anyone does currently have that experience, and then I can talk to kind of the committee, or I'm sorry, the working groups process. And I've already given the chairs this disclaimer, but I also as staff the Committee on Professional Responsibility and Conduct, and I refer to committee a lot, so I apologize when I misspeak and say that instead of working group. Okay, so I see Judge Lucky has raised his hand. And is there anyone? Oh, Claudia, thank you. Sorry, apologies. So we do have some representation, and here's, let me just kind of give you a sense of the working group. So, and we will get to this with the charge in a little bit as well. But the working group is a staff created working group. So there's no direction currently from the Board of Trustees to be engaged in this working group. This was done because Senator Umberg through SB 940 has indicated that the State Bar must create a voluntary certification program in this space. And we certainly want and value so many different voices in this. But at the same time, we need to get this done. And I will say this, and this is not specific to adding a family law expert in this space, but it's in regards to adding just more. As you can see, there are a lot of boxes on this screen, and we have a lot of work to get done. And the benefit of having more voices is more perspective and more viewpoints, but it's also can be a detriment to getting that work done. As we'll get to, there are going to be numerous opportunities for public comment throughout this process at this level of the working group, and then whatever work product is given to the Board of Trustees, if it's in the form of rules or frankly anything else, the Board of Trustees will be issuing it for public comment. So voices will be heard if they want to be heard. I would just I would give my perspective that this is already a very large group, and if we start to expand it for voices that certainly have a lot of value, it's going to become more difficult to move forward and create positive momentum in a timeline that makes sense for the state bar to implement this at a staff level.
All right, Ron, is that acceptable to you?
I'm sorry, is what acceptable?
That we not take a vote on your motion at this time?
No, I put that motion forward quite deliberately.
Right, well,
I'd
let's-
like to hear any other discussion about it, and I'd like a vote from the committee if that's acceptable.
I'm sorry to interrupt you. Yes, let's see if there's a second.
I'll second his motion.
All right. Is there any discussion?
I would ask that the folks who raised their hands, maybe Clea, for example, could tribal or about experience, because I think it's a really valid concern. And if I'd like to understand whether we have representation.
Okay, you broke up a little bit, but I think we understand what you said. You wanted to hear from the people whose hands were up.
Yes,
Okay.
sorry about that.
All right, Cliff?
Yeah, this is more of a point of order, only because Ron's made a motion, without regard to the merit of it. I just would like, I guess this fits into what Erica was going to talk about next, the process. I'm not very familiar with the Rosenberg's rules. And it's important for me to know whether we're going to be voting and majority vote on these important issues, because it really impacts the viability of what we're doing based on the makeup of this committee altogether. So I'm just wondering if there's a proper role for motions, or how we're going to be deciding things, or what we can do to facilitate in protecting the public as opposed to protecting the industry.
All right, thank you, Cliff. And I saw another hand. I don't see, okay, Katie.
Could you restate the motion or put a copy of it in the chat so that we can refer back to it as well?
I'd be happy to restate it if that's what you'd like.
Thank you.
And I think the chair is going to restate it for everybody if I understand Rosenberg's rules correctly. But my motion is that the working group vote to request the appropriate authorities within the state bar to expand this working group to include at least one more member who would be a practitioner of divorce and child custody mediation. And if that's staff, I stand corrected. I understood that the bar itself was the one that decided the working group. If staff decided it, then it'd be a motion to staff. But my understanding would be that it would go to the Board of Trustees. That was the intent of my motion.
All right, thank you. And Judge Lucky?
Thank you. I was just going to clarify, number one, me raising my hand, and number two, just to make sure that we're all on the same page on child custody mediation. So first, I raised my hand because I'm involved in family law mediations, and part of my practice is custody and visitation of children. However, I think, just to inform people who are unfamiliar with what we call child custody mediation in a family law context, if I remember correctly, cases that come under Welfare and Institutions Code Section 300, what we used to call juvenile dependency cases, but I think that that's the name by which most non-practitioners would be familiar, have a similar type of process. And they may or may not be people that we need in this working group, in the sense that those child custody recommending counselors, as we call them in certain counties, or child custody mediators, which other courts call them, and for our purposes here, I don't know that there's a meaningful difference, are court employees who are generally not lawyers, although some lawyers do become child custody recommending counselors or child custody mediators. They have a mental health background, and those are court mandated programs where court employees either mediate and or make recommendations to the court. The reason that I say it may or may not be applicable to our work here is that since they are court employees, and since these are state mandated mediations that are a slightly different creature than are what I'm going to call consumer facing or business facing types of private mediation in which most of us engage, I don't know that our work would be meaningful to that group of mediators, since they're creatures of statute and their work is largely governed by statute. And I just want to be clear, I am a non-voting member. I'm here as a liaison for the California Judges Association. So I'm giving this as information, but I am not expressing an opinion one way or the other. Just wanted to make sure that everybody was aware of what child custody mediators did and in what context they worked.
And let me clarify my motion then. Divorce mediators who routinely handle questions of child custody between divorcing parents is what I meant to say, as opposed to the mediators that operate under Welfare and Institutions Code 300.
Okay, all right. So are there any other comments? Claudia, yes.
Thank you, Judge Pichon. So when I read that letter from the American Matrimonial Lawyers Association, it wasn't that there wasn't any representation of family law in this working group, because I'm a family law mediator. It's that there wasn't representation of someone in family law from the bench or the bar. And it sounds like Judge Lucky actually has that experience. So based on that, on their letter alone, and Judge Lucky being here, it sounds like the requirements have already been met.
And just to be clear, I was in family for 7 years and supervising judge of family for 4. And so I'm familiar with a lot of family law mediation and private mediation for custody and visitation as part of my practice.
All right, thank you.
Claudia, if you're a family law mediator, then I respectfully withdraw my motion and apologize for taking the working group's time.
All right, thank you. We'll move on to the next agenda item, and that is the introduction to the working group process, and that is being presented by Erica Doherty.
Thank you, Judge Pichon. I'm going to share my screen, and hopefully you will be seeing slides momentarily. Can everyone see them?
Yes.
Okay, great. And then Cliff, we did hear your questions about how process will work, and that will be part of this presentation. In the interest of time, I'm going to be as brief as possible. I was going to spend 15 minutes on this, but we may reduce that. So I'm just going to preface this by saying, do please reach out if you have questions on any of these things. This is going to be a very quick and high-level overview of most of what's here. So first, we're going to go ahead and discuss the Bagley-Keene Open Meeting Act requirements, moving to the Public Records Act, Rosenberg's rules, which will be the parliamentary procedure for this working group, and then other working group processes, as well as contact for State Bar staff, the website, and SharePoint as well. So let's start with the Bagley-Keene Open Meeting Act. And with a few exceptions for the State Bar standing committees, all State Bar committees, commissions, ad hoc commissions, and working groups are subject to the Bagley-Keene Open Meeting Act. What this does is it sets forth notice and agenda requirements, provides for public comment like we heard earlier, and requires that meetings be conducted in open session unless there are certain requirements met to move us into closed session, that will be unlikely for this working group, as well as outlines ADA accessibility requirements for meetings. Meetings, as you'll see, are broadly defined, and it includes any congregation of the majority of the working group to hear, discuss, or deliberate upon any item that is within the jurisdiction of the body, meaning what's within the charge, that we'll be going to in a moment. For this working group, the majority is 11 people. So this means that an unauthorized meeting that is not properly noticed, without an opportunity for public comment and so forth, cannot occur. And what that means is that the members cannot use a series of communications of any kind directly or through intermediaries to discuss, deliberate, or take action on any item of business that's within that charge. So briefly, there are several requirements for meetings. One is to post the agenda within 10 days or 10 days in advance. It must include the date, time, and location of the meeting. All of our meetings will be on Zoom. And then only items that are agendized can be discussed, absent some very limited exceptions, and there must be an opportunity for public comment. There are some exceptions for special emergency meetings that have less than a 10-day requirement. Again, unlikely that the work of this group would have those types of meetings. Okay, what is not a meeting? And I think this is going to be important for several working group members. So if any of these things apply to you, do not hesitate to reach out and we can kind of talk through them. Basically, anything that's not prohibited by Bagley-Keene, of course, is not a meeting. Attendance of the majority of members at a conference or similar gathering that's open to the public that involves a discussion of issues of general interest to the public or of the working group, so long as the majority of the members do not discuss among themselves the work of the working group other than what's part of the scheduled program. And then there's also some limitations there that working group members can't be offered to attend that for free when others have to pay. And then other basically social events. So other meetings, other ceremonial or social occasions, again, working group members can attend so long as the business of the working group is not discussed at those meetings. What I want to talk about, which is where this can get complicated somewhat quickly, is that, like I said, a series or a serial meeting can occur. And that is where a majority of members, through what's called a daisy chain or a hub and spoke communication, ultimately communicate with one another. So that's where, for example, once we get to subgroups, if there's a subgroup that has 9, and then someone from that subgroup reaches out to another person on the working group who then reaches out to another person, we will have had a majority communication, which is a serial meeting that would violate the Bagley-Keene Act. So there's 2 common iterations, like I said, daisy chain communications, which is where A talks to B, and then B talks to C about that conversation, as well as hub and spoke, where one person talks to several individuals about the same topic. That violate the Bagley-Keene open meeting requirements. So like I said, this is a very fast overview of this. There is a Bagley-Keene FAQ that has been posted on our SharePoint that goes into it in a bit more detail. And of course, if you have any questions about particular issues, please don't hesitate to contact me. Turning to the Public Records Act, the State Bar is subject to the California Public Records Act, which makes records of the State Bar presumptively public, absent certain exceptions. What that means is that any writing that's prepared by staff or anyone on this working group that relates to the working group's work could be subject to disclosure. That includes emails, it includes text messages, and it includes documents that are stored on personal devices. So for that reason, we strongly recommend that you include a staff member on those communications, so that way if for some reason we get a Public Records Act request and we have to search for that information, they are searching my personal devices and searching through our network as opposed to yours. And then, of course, just please be mindful that because these things could be subject to public disclosure, just be mindful that what you say could be public. Okay, Rosenberg's Rules of Order. So those are for those of you who have participated in committee work, it sounds like most of you have. You are probably used to Roberts. Rosenberg's, I'll just say from my perspective, is much simpler to follow. It's much shorter and it's much less complicated. If we need to, we can get into the number of motions that can be on the table and so forth. However, for just a high-level overview, what I'll say is a quorum is a majority of members. So again, that's 11. And then the majority in a vote is determined by present and voting. So only the yeses and nos count in a vote, and abstentions and recusals decrease the voting pool and do not count towards a majority or a no vote. The chair has the ability to vote, but does so last. And most motions, in fact, nearly every motion for this working group just requires a simple majority, but a tie means that the motion fails. Okay, other working group processes, and again, my apologies for going so quickly. I just want us to get to the substance of today. So Zoom protocol, most of you are already following it, and thank you so much. So it's just, we ask that, you know, to the extent you can, because it's such a large group, when you're not speaking, your microphone is muted. To the extent feasible, we realize these are long meetings. If you can please try and stay on camera, and that's because when your camera is off, those who are watching from the attendee group cannot see that you are here. During breaks, which we will have hopefully soon, please stay in the meeting. You can go off camera at that time, and certainly please mute your microphone. And there will be a slide that's posted on the screen so that the attendees know that we are on a break, and it'll indicate the time that we will be returning to the meeting. Attendance. So we are really happy that everyone was able to attend this first meeting. I hope that everyone is able to attend every meeting. However, I don't know that that's realistic for a group of this size. So we did send out a proposed schedule for the working group through September. 3 of you have given us feedback. Well, more than that have given us feedback, but 3 of you have already indicated meeting conflicts. But the most that we have received so far are 2 conflicts for 2 meetings. Otherwise, it appears that the current schedule works for everyone. If that is not the case, during our 15-minute break, and you haven't checked already, if you could please look through the calendar and let us know if there are any meeting conflicts, because we do want to set that schedule for the benefit of everyone who's participating in these meetings. Finally, like I said, you know, please use Alan, Angela, and I as resources. We're here to help you. We encourage emails. We will do our best to respond as quickly as possible. And then one last thing is that we have set up SharePoint access for you all. If you have not tried to access it already, we encourage you to do so as soon as possible. Sometimes firms and organizations have firewall settings that make it difficult to access. So if that's the case, we will connect you with our IT team at the State Bar to get you access to that. And what is on that SharePoint and what will be is, you know, the roster of the committee, that Bagley-Keene FAQ, past meeting materials for these meetings that are publicly posted, and so forth. So it's just kind of a one-stop shop for all the resources related to this working group. All right, that concludes my very brief and very fast presentation on housekeeping items. If you have questions, we can certainly, you know, take them now, or we can, of course, you know, delay that to a future time. And I know that questions will come up too as this working group moves forward.
Thank you so much, Erica. You got us pretty close to back on schedule for our time. And next, we're going to take up our action item for today, and we're going to review and approve the working group charge. And that's back to you, Erica.
Okay. I will share my screen again. And so all of you should have seen the working group charge. This is something where if there's we would ideally like a motion in this space ultimately. I will note that I have already redlined a duplicated sentence in what was provided to you, so my apologies for that. But this is essentially what is proposed to be the working group's charge, and if adopted, this would guide the committee through its work throughout you know, the time that we will be together. What I will just add is a few points related to the work of this working group, in case it's helpful as it relates to the charge. So what is intended is for there to be full working group votes at incremental stages of the working group's work product, as well as a final vote for the overall work product. What staff thinks that work product should look like is ideally a set of rules. So the State Bar uses rules, and those rules are approved by our Board of Trustees. And what those rules look like are essentially procedures. So this would be a certification procedure. It could be multiple certification procedures for mediators, arbitrators, and so forth. That'll be something that Alan will discuss later on today, or it could be one set of procedures. I leave that to this group to start to consider. But again, it would be votes at incremental stages. So voting, for example, the working group votes that this is their recommendation for the lowest tier of certification, for example, and then voting on what would be in the tiers, what would be in the complaints and remedies processes, and so forth. Then the working group ideally will vote on something that can be issued for public comment at the working group level to get input from all of those stakeholders, again, that are unable to participate just because there are so many of them in this working group. Ideally, the working group would take that public comment, make revisions as the working group feels appropriate, and then vote to submit this to the Board of Trustees. So the deliverable itself would be essentially State Bar rules. Now, what would go with that deliverable would be something prepared by staff, which would be a staff memo. And what that would do is it would explain, how the votes were, if there were majorities, that would be what was recommended. But if it's close, or if there's a dissenting viewpoint that, it should be included, there would be a memo that discusses those things. And then also, these are recommendations that are going to go to the Board of Trustees. This does, as I mentioned in one of my concerns related to this, it does need to be something that staff can actually implement from a certification perspective. So if there is a proposed rule that this working group thinks is fantastic, that is wonderful, so long as we can actually implement it. If it's not feasible, that's something where staff would include in the memo that, this is a great idea, however, it's not feasible based on resources or what have you. So that's essentially what we're hoping for at the end would be, again, State Bar rules, and then there would be an accompanying staff memo that would go with that to the Board of Trustees.
Thank you, Erica. And I see a number of hands that are up, and your questions can certainly be on Erica's first presentation as well as her presentation regarding the charge. So I see Diana.
Just briefly, I wanted to make sure that there's no prohibition on us creating summaries of these meetings for the groups that we represent.
No, so these meetings are public, and sorry, I should apologize. These meetings are public, anyone can attend. They're also recorded, and they will be publicly posted. So the State Bar has a YouTube channel. You can rewatch this if you have that time and would like to. You can watch it at up to 2.0 speed as well. So again, tied back to kind of attendance, anyone who wants to watch this can. You can certainly take notes and share those out, so long as you're not sharing them out with a quorum of this group. Anyone could watch the recording as well, of course.
Jill.
Hi, thank you. Two questions. I guess one is a comment. If the comment was whether anybody had indicated standing conflicts with 2 meetings, I certainly have a standing conflict with more than 2 meetings, which I think I responded on. So I may be the only one that's in that boat, but it was at 3 meetings. So that's really more of a comment than a question. The second is in terms of deliverables. You mentioned, Erica, that we're looking to do State Bar, proposed State Bar rules. I also heard Mr. Umberg saying that if there were recommendations about legislative changes, that we would make those, and I would ask that we consider whether that's appropriate as we're moving forward. There may well be things that we would propose. So I don't want to lose sight of that.
Thank you. And Jill, I don't want to, I may have misspoke. I apologize. There were 2 people that had 2 meeting conflicts. We did note that you have 3 meeting conflicts, but so far there's very few people, there's not a large number that have particular meeting conflicts, unfortunately.
Ron.
Thank you. I want to speak in favor of this, and if time comes, make a motion, but I also want to comment I really appreciate the fact that staff has phrased this in a way that eliminated the term I find offensive from the first solicitation of who wanted to be a member of this working group, and that term is non-attorney. I know it has been appropriate for the state bar when it regulates attorneys to divide people into attorney and non-attorney, but now it's being called on by the legislature to expand its purview quite considerably to people who come from mental health backgrounds, people who are just simply volunteers in community programs potentially, and referring to people by what they are not is simply offensive to many people. I would not refer to Ms. Doherty as a non-male, and I don't think she'd appreciate it if I did. So I'm speaking in favor of the wording of this, and that I think it represents a progressive change from the solicitation I first saw for this working group. And thank you for paying attention to that phrasing, Ms. Doherty.
And Jill, your hand is still up. Did you have something else? Okay. I didn't see any other hands up. Please let me know if I have overlooked you. Okay. Are there any other comments regarding the charge since we will be voting on it? Is there anything anyone else would like to ask about that or make a statement about before we take a vote? I want to make sure everybody's heard and understands the charge. Okay, I'm carefully checking and I don't see any hands. All right, would someone like to make a motion?
I'll make the motion.
Second?
Thank you. So the motion, there has been a motion by, I'm sorry, I didn't, let me see who made the motion.
Diana.
Thank you, Diana. And Ron, you seconded?
I did.
Okay. All right. We'll go ahead and take a vote now.
Okay, taking the vote. Armstrong,
Yes.
Coulter,
Yes.
Curtis, Dinkin,
Yes.
Dubo, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Copaken,
Yes.
Cruz,
Yes.
Lowe,
Yes.
Gillespie, Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
and Judge Pichon.
Yes.
So the motion carries with the majority voting in favor.
I was on mute.
Oh,
Yes,
Dana.
Curtis.
Thank you very much. Okay, Dana, what was your vote?
Yes.
Thank you. So the motion still carries.
all right. Thank you. All right, next on the agenda is sorry, break. I'll just keep you going right until 5 o'clock. So it's time for a 15-minute break. So it is now 3:39, let's say 3:40. So we will be back for 3:55. Yes. All right, see you back at 3:55. And remember, don't turn off, just walk away. All right. I want to say we're back in session, but that's from being in court. So it looks like everyone is here and it is now 3:55. Our next item is 2.4, and it is an overview of Business and Professions Code, Section 6173. And this item is being presented by Alan Weiner, and it is for discussion only. Alan?
Thank you, Judge Pichon. And I'm trying to share a screen here. Let's see if that'll happen. There we go, maybe. Hopefully you're seeing my title screen. Hello again, and thank you again for lending your expertise and time to this initiative. I want to begin this agenda item with a short roadmap for the next two agenda items, this one and the following, both of which I'll be leading. For the next 10 minutes, I'll be going over the provisions of Business and Professions Code 6173 and highlighting some possible topics that the working group may want to discuss and address in the course of this project. With your permission, I won't pause for questions or comments during this slide presentation. And then for approximately 45 minutes, I'll display what we're calling the topics for possible working group consideration document, or for short, the topics document, which I hope you've all received and had a chance to look over. I will display the topics document and invite the working group members to suggest revisions to it. The purpose of this later segment will only be to identify possible topics that the working group may want to consider in the course of its work, and not to discuss whether or how those topics might ultimately be addressed. For those of you who are interested in artificial intelligence, Erica provided the text of section 6173 to napkin.ai and asked for a graphic presentation. This slide reflects the provisions of subdivision A on the left side and subdivisions B and C on the right. As we're all learning, AI isn't perfect, so we'll be looking at the statute more closely than this slide reflects. First of all, eligibility for certification is very broad under the statute. It includes ADR firms, providers, and practitioners. And certification may not require state bar licensure, allowing for more inclusive certification of practitioners from different professions and walks of life. Alternative dispute resolution is broadly defined in the statute. The definition specifically includes arbitration, mediation, and conciliation, but more generally, it includes any other non-judicial procedure that involves a neutral party in the decision-making process. The statute establishes two types of minimum requirements for certification and allows the state bar to establish others. First, the statute requires that arbitrators and mediators adhere to specified ethical standards. Arbitrators must comply with the ethics standards for neutral arbitrators in contractual arbitration adopted by the Judicial Council. And mediators must comply with the ethical standards equivalent to the rules of conduct for mediators in court-connected mediation programs for general civil cases, also adopted by the Judicial Council. The statute does not specify what ethical standards, if any, conciliators or other type of ADR practitioners must adhere to. The second minimum requirement for certification is that a certified firm, practitioner, or provider must have procedures for making complaints that an arbitrator or a mediator failed to adhere to the specified ethical standards, and procedures to remedy failures to adhere to those standards. The certification program must also provide authority for the state bar to deny or revoke certification for a failure to meet or maintain the certification standards. Section 6173 also requires that there be different levels or tiers of certification and sets forth three requirements for those tiers. First, higher tiers must be awarded to firms, providers, and practitioners that demonstrate higher levels of commitment to accountability and consumer protection. Second, the tiers must not reflect an assessment of the quality of a firm, provider, or practitioner. And third, the requirements for tiers may only reference the standards of conduct specified in the statute. Finally, the statute essentially requires that the certification program be self-funded. It authorizes the state bar to charge fees to cover the reasonable costs of administering the program. And it provides that the fees may be higher in the early years to cover the cost of establishing the program. It further provides that no funds from the state bar's attorney licensure fees may be used to cover the certification program costs. So this slide and the following slides highlight some of the high-level topics that the working group may wish or need to consider as it pursues its work. We'll revisit these and other topics soon when we review the topics document. But essentially, we're going to be talking about certification of practitioners, ethical standards and other qualification requirements, certification of firms, the same two bullets, the tiered certification structure, and program administration. So first, as mentioned, the statute specifies arbitration and mediation, but more generally refers to other non-judicial procedures. So the working group may wish or need to consider what other processes the certification program might address, such as meet-arb or neutral evaluation or ombuds, private judging, reference, and perhaps others that are omitted here. Also, as mentioned, the certification of practitioners, arbitration, mediation, conciliation, and other processes provides for the adherence to ethical standards. So the two sets of standards, one for arbitrators and one for mediators, referred to in the statute. But the working group may look at what other existing models there are, such as standards, ethics standards for ombuds folks, for example. A second thing after ethical standards, what other qualification requirements might the working group recommend be conditions of certification? These are not set forth at all in the statute, but again, the statute broadly allows the state bar to adopt a program that includes but is not limited to the minimum requirements specified in the statute. So the working group may want to consider matters such as whether specific levels of education, ADR process and training, experience, continuing education references, etc., should be required as conditions for certification. And this working group will probably need to consider how these requirements should apply to baseline certifications and to tiers, as well as to initial certification and to recertification. While the statute provides that the certification must provide for, the program must provide for certification of firms, providers, or practitioners, these terms are not defined in the statute. One question the working group may discuss is whether provider might be interpreted to encompass firm and practitioner. And another may be whether firm and practitioner could be collectively referred to as provider organizations to better distinguish between organizations and individual practitioners, or whether there are distinctions between firm and provider that need to be addressed in the model rules. So certification of firms, the statute again refers to ethical standards for certification of individuals or of arbitrators and mediators generally, but it doesn't set forth standards, ethical standards for firms or organizations. So what ethical standards, if any, should firms or organizations be required to adhere to in order to be certified? And what other qualification requirements, baseline and tiers, might firms be required to adhere to? And again, how do these relate to initial certification, to recertification, and to baseline certification, as well as tiers? Complaints and remedies. The statute specifically refers to the requirements for addressing complaints about court program mediators, but are these complaint procedures suitable for addressing complaints about other types of ADR practitioners or about ADR practitioners outside of the court venue? Again, as some have raised already, what will be the confidentiality of the complaint procedures and outcomes? And other questions may include, should individual practitioners address complaints about themselves? And should firms address complaints about themselves or their members or practitioners? And if the answer to either of those questions is no, then how should those complaints be addressed and by whom? With regard to tiers, again, the statute requires that the tiers demonstrate higher levels of commitment to accountability and consumer protection, but not reflect an assessment of quality. So the working group will need to consider and perhaps wrestle with what criteria would accomplish both of these requirements. Also, the tiers may only refer to the ethics standards specified in the statute. So a question arises about whether baseline certification may require adherence to other ethical standards, such as standards for firms or standards for ADR processes other than mediation and arbitration. Perhaps more mundane, the working group may wish to make recommendations concerning some of the program administration aspects. As Erica mentioned, this is going to be a concern of staff. How is the program going to be implemented? And so issues like the application process, decision makers and timeline, fees for certification, duration, evidence of certification. For example, if there's a type of seal that certified practitioners or firms can use, what are the conditions and limitations of the use of that? And then if there are disagreements with the decision that's made, both about initial certification or perhaps about decertification, what will be the processes for review of those decisions? Erica, would you like to make any additions or corrections to the provisions that I've just gone through at this time?
No, Alan, thank you. I think you covered it well.
Okay, great. And then Judge Pichon, unless you or Dr. Getz have questions, comments, or other ideas at this time, I think we may be ready to move to the next agenda item.
I don't have any.
And I don't have any either.
All right. So Alan, does that mean you're going to move to item 2.5?
If it pleases the chair.
And that's discussion regarding areas of focus for working group consideration. And this is on for discussion also.
That's right. And I am going to try and share that document, although I hope that you have that at hand, because it's going to be hard to look at and read some of these things on the shared screen. How is the size right now? Erica, does this seem appropriate, or do we need to make an adjustment?
I see a few people kind of leaning in. I would defer to the group. I have the benefit of more than one screen. For those of you, you can also toggle on your screen between to make either the Word document bigger and the attendees smaller if you want. There's kind of a division with 2 bars, and you can adjust for yourself if you need to.
Right. And this challenge is the reason that we suggested that you have a hard copy or a screen showing these qualification requirements. It's just difficult to look at some of the finer print and bullets on a shared screen in Zoom. So the basic construction and origin of this document is that staff looked at some of the major issues that we thought the statute was going to require the working group to look at. So the first, for example, is the qualification requirements for arbitrators. And below each of those requirements, we have pasted verbatim the provisions of the code which may pertain to that issue. And then we have come up with some what we think are discussion topics that the working group may wish to consider. And here's where we'd like to invite you to give your input about whether there are things, areas where you feel we missed the base, where there are things either that the working group perhaps shouldn't consider or additional things that should be considered but are omitted. I do want to repeat, though, that right now we're really just trying to get a scope of the topics that the working group should be looking at, and not to discuss the merits of those, because obviously we could have a full meeting just addressing some of these individual topics. So you're welcome to comment on these. I hope you can see them. The numbering on this first one is a little bit off, but at the high level, are the Judicial Council ethics standards for neutral arbitrators and contractual arbitration adequate, or should there be differences? And a couple of you, including Mr. Pilevsky, have commented on this. And we had a comment excuse me, from one working group member that's added in green here about whether amendments to those ethics standards may be necessary. So what other ethical standards or codes might the working group draw from? Are there other existing qualification requirements for arbitrators that the group might draw from? And what additional qualification requirements should the working group consider? So I invite anyone to, I guess, raise your hand is probably the best way. And Erica, I am not seeing the Zoom screen, so maybe if you can, oh, I see Mr. Tuckman has raised his hand. Yes, please unmute yourself and speak.
It's just a question. There are a number of additional ethics standards, for example, that exist, and some are sector specific. International arbitration or investment treaty arbitrations are governed by ICSID transparency standards. It's a question. Do you want just to create a list of things that could be used as a resource? Or is the question whether we need to consider additional guidance?
Well, I think if there are other documents existing, that it would be great if we could capture those. And my goal is to try and do this in track changes so we can capture what your suggestions are and then come back to them. So do you want to suggest a couple? I think you said international. What was the?
Yeah, there's the, let me give you the specific name. It's the ICSID, International Center for Settlement of Investment Disputes Code of Conduct for Adjudicators from 2022.
And I'm just going to come back and get the full title later.
Sure. The International Bar Association has guidelines on conflicts of interest and international arbitration as well. I think the Court of Arbitration for Sport has a code of conduct as well.
Sorry, what was the last one? I missed that.
The International Court, I'm sorry, I'm looking it up.
Okay. I'll try and correct some of my spelling errors while you're doing that.
Yeah, it's the Court of Arbitration for Sport Code of Ethics. That's what it's referred to.
For sport, did you say?
Court of Arbitration for Sport, CAS.
Okay,
yes.
Great. And, I should have said earlier, we intend this to be a living document. So if there's something that you're not thinking of right now, or that you'd prefer to submit to staff by email later, that's totally fair game. So Mr. Yamshan.
Thank you. With the educational requirements, most providers have educational programs, and often they require periodic updates annually and sometimes even more often. I'm wondering if the working group is going to recognize their educational programs as qualifying. I'm wondering, are we going to develop specific curriculum requirements, things such as that nature? I may be jumping the gun, but I can see no reason to require somebody coming in as a neutral under 4.1 to have a diploma or a degree, because honestly, the best mediator I have ever met was a hairdresser. And probably the greatest active listener on the planet Earth. So that's preview of coming attractions for a future discussion. But I think there's so many educational things going on, county bar ADR sections, the American Bar Association dispute resolution section, annual meeting, and all their various committees. There's a lot of education going on around the country all the time. And I think we have to take into account all of those opportunities. And we may or may not need to develop specific curriculum requirements.
Sure. I realize that you don't have the benefit of seeing the screen, or maybe you do and you just use too much bandwidth if you display your picture. But we do have other existing qualifications that the working group might draw from. And then we also have continuing education highlighted there. Do those two fairly capture the topics at this point, recognizing that the discussion of hairdressers and gang member mediations as well
Right.
might follow?
Yeah, I did download the document when it was sent out, and I was looking at 4.4 and 4.1 when I 4.1 when I raised the level of education,
Yes.
and 4.4 continuing education. And in terms of that, I think at some point we also need to think about grandparenting some people in who've been just doing this for years and years and have a world of experience. They're teaching it. And so I think we need to recognize some of that.
Yes, and I have that's a new suggestion really that we didn't have on this list, grandparenting, and I have added that. So
Hey,
thank you
thank you.
thank you for that suggestion. Mr. Pilevsky.
Hi, just to complete your list in the twos there. There's a principles for ADR provider organizations from May 1 of 2002, created by the CPR Georgetown Commission on Ethics and Standards. I had sent a copy of this to Erica. It would be, I think it's a good document for everyone to read. And just as a point of information, you have the ABA AAA Code of Ethics. There's actually two of them. One was in 1997. That's 1977. And I believe they were updated in 2003 with some very significant changes, not all positive to my mind. So we should be clear which one we're looking at.
Sure. Thank you for that. And just to mention later, we do have, we did appreciate your suggestion about the CPR Georgetown, and we have captured under those under the topic for firm, certification of firm.
Right.
So thank you again for that. Ms. Cruz?
Just quickly piggybacking on Eric's comment, and this does not stop us from considering the international guidelines that are available from many communities, but we have heard at some of the organizations that I represent that international arbitrators are concerned about this potential applicability of this certification process to them in toto. So their point of view, some international arbitrators, is that this new law is directed solely to the Domestic Arbitration Act and not to international practitioners. And so I think that's, maybe on just a broad applicability note for us to consider. With maybe on the same line of what do we do with ombudsmen and special masters, et cetera.
Yes, and I will say we also do have a topic at the end about certification of folks from outside of California. I think we were thinking more about other states, but international is certainly a helpful suggestion to, for the working group to consider. So thank you for that. Ms. Curtis?
Yes, I think that we will need at some point, probably fairly early on, to address this question of whether we're developing guidelines or standards, and what sort of language will we use? Will it be must, should, shall? And looking at some of the other standards without dwelling on it, for example, JAMS mediator standards, mediator guidelines are all they all really relate to a mediator should. And some of the rules are, some of the guidelines are, they say they're guidelines, but they say shall. So, I think we need to provide that clarity for everyone.
Sure, thank you for that. And I'm capturing things in a way that they don't necessarily fit in the outline, but we'll take care of the organization of that later. We won't use your time for that. I'm not seeing any other hands on the qualifications for arbitrators, so I'm going to move on to our next topic, and I don't know why these numbers showing number 4, but qualification requirements for mediators. So again, we kind of have the same discussion topics. Are the rules that referred to in the statute appropriate? Or should there be other requirements or perhaps suggestions to amend those rules? I'd also note the equivalent to the statutory language is mediators must adhere to standards that are equivalent to the rules of conduct for mediators in court-connected cases. We've identified a few other standards of conduct for mediators that the working group may want to look at. If you have additions you'd like to suggest at this time, they would be welcome. And then the question is whether there are other qualification requirements for mediators that the working group might draw from. And by other, I mean other than adherence to a set of ethical standards. Again, things like education, continuing education, and such. Anyone want to? Yes, it's Curtis.
Thank you. In looking at some of the other guidelines throughout the country, I looked at Florida. I think that's the one that has a requirement of good moral character and having references. And I thought that's very interesting, and it does mirror what the bar requires to practice law. So anyway, it's worth thinking about, I think.
Thank you for that. Mr. DeBow.
No, there's a lot of different standards out there, and we can't handle them all. I would have this suggestion that we have a situation where we certify the standards. That is, let's say I go out, I start my own provider and mediation, and I require my mediators to adhere to a certain standard or standards. I would then submit those standards to somebody at the state bar who's running the certification program, and the state bar would approve my mediation standard. And therefore, once they approve that, or it approves that, then my mediators would be obliged to adhere to that program. And that may solve the problem of these myriad types of standards. And for example, you may have an arbitrator in some other state comes in here to arbitrate a dispute. He's not bound by the ethical standards, I don't think. I'm not sure about that, but he may be bound to standards in his home state. So that would be part of that program.
Understood. So the idea is that there could be more than one. I mean, the rules that might be proposed could provide that an arbitrator or a mediator should adhere to one of the sets of ethical standards approved by the state bar. Is that your suggestion?
Yes.
Great, thank you. Anyone else on this general topic of qualification? Mr. Armstrong.
Yeah. As to, I guess 4.5 and 4.6, they're probably interchangeable in this respect, but I know that for some of the court programs in the Bay Area, when you're looking to get on a mediation panel for one of the superior courts, there are some pretty rigorous requirements in terms of experience, oftentimes upwards of like 40 hours of either mediation training or having experience personally handling mediations. And I think that has proven a real barrier to practitioners joining the panels, just because of the time that's required when you already have an active practice to get certified, so to speak. And I know personally a number of lawyers who haven't done it, and in some instances haven't volunteered their time even to do it, just because of the time commitment that's required on the front end. So I do think we need to be careful if we are going to set education standards or experience standards that so that they're realistic in terms of what people are going to be able to accomplish and achieve.
Thank you for that. And just a comment. So there are model qualification standards for court-connected mediation programs for civil cases. So I put that here, and I've noted your remark about other court standards down below that. Mr. Dinkin.
Yes, I wonder, we talk about education or expertise in terms of mediation, but I wonder if we should also consider a subject matter expertise, if that's, for example, if it's a construction defect matter, then when we talk about experience, is that experience as a mediator or experience within a certain subject matter area? So
Okay,
you wouldn't
thank you
want
for
a
that.
family law person handling a construction defect matter, or someone in real estate handling a family law matter.
Right. Yeah, so it raises the question of whether a practitioner might be certified for all areas of practice or even for all types of ADR, or whether it's more refined than that, the system. So we'll be talking about that elsewhere. Any other suggestions at this point on the discussion of possible qualification requirements for mediators, or should we move on? Okay, seeing no hands, I'm going to move on. Again, this is a living document, so as you reflect on it, please send further suggestions to staff. As Erica cautioned, don't send them to the whole working group because that may create a Bagley-Keene issue. All right, so the next major heading we have is qualification requirements for other types of ADR practitioners. So again, the statute refers to arbitration, mediation, and conciliation, but then it also says other non-judicial procedures that involve a neutral party in the decision-making process. So, some of the topics the working group will likely need to consider is what other types of dispute resolution should be addressed by the certification program, and what should be the ethical requirements and other qualification requirements for those types of ADR processes. So we've listed a few, again, types of practices, of ADR practices here, and we've also tried to capture some existing standards that ethical standards that govern those other types of ADR practices. And then we go through the same kind of a list of different things, education, experience, et cetera, that the working group might consider, and potentially for each of those other kinds of ADR practices, I suppose, which is a little daunting. Yes, Ms. Jones.
I just wanted to comment that the CCP code sections relevant to referees were incorrect. If you scroll up a little bit, please. Here, 2.3, those should be 638 and 639 rather than 838.
For that. And Mr. Pilevsky.
This is a pretty modern problem here. I received an email promoting a new ADR firm where the decisions were made by AI, not a human being. I get the sense that the statute contemplated a neutral person, and I'm looking at your list of other options here. I just want to throw that out there, that there seems to be a proliferation of new AI neutrals, if you will, and how they should be impacted, if at all, by this working group.
Yes. Yes, and there are books about that, and people who are, much more knowledgeable than I, but Colin Rule comes to mind. Thank you for that. Ms. Ellis.
Hi, thank you. I was thinking it might be appropriate to add a general high-level point regarding what non-judicial means. My view, for example, is that discovery referees appointed by a court for example, under CCP 639, they sign off that they're adhering to certain ethical rules applicable to judges at that point. So are we creating a conflict with that? Is that an area we need to go into? So just another thought there.
Yeah, thank you. And I've added that as a high-level topic. Ms. Jones, I see your hand is still up, but did you want to lower it?
That was it. My apologies.
Okay, thanks. Mr. Kelly.
Couple of points. One, if I understood the author, Senator Umberg's intent, it was definitely to cover people that were the subject of the LA Times scandal stories, all of whom were theoretically under the supervision of a court, the state bar, the Commission on Judicial Performance. So I think that we shouldn't dismiss the idea that because they're under some other jurisdiction, the legislative intent was to skip them. That's one. In terms of language, it looked like there was a confusion that some people had, or maybe staff had, between practitioner, provider, and firm. And I would think that a firm would have to be incorporated. And I don't know that all providers are incorporated. There could just be a group of 3 people considered a provider group. And I assume that's what the legislation was getting at. You don't have to be an incorporated firm. You might be a state bar for that matter. Maybe that's incorporated as a nonprofit. In terms of other types of ADR firms, as an example, there are dispute review board members who have a very large role in trying to head off public works fights. And it might be worth thinking about what that would mean to include them.
Thank you. Ms. Cruz.
Just along the lines of Ron's comment, I think that we can't forget where the statute came from. And I don't know exactly what the title of the neutrals was when they were distributing or signing off on fund distribution. I think it may have been special master, but I think we should investigate exactly what title they were operating under and make sure that people, neutrals filling in as fund distributors should probably be covered, since that's where that statute came from.
So I've added the statute that the neutrals in the Girardi matter were operating under. Thank you for that. Ms. Kopeckin.
Hi, yes, thank you. Following on Mr. Kelly's comments, I think I would like clarity on, does provider include, for example, my court program? Is the court a provider? And so I think we need to consider that. Following on comments by Ms. Ellis, and I'll let you catch up.
So I'm gonna capture that if you'll bring that back up again, because we're gonna talk about, I'll have a little segment on,
Sure.
On those definitions. And I definitely want to capture it there, but I don't want to make everybody dizzy
Yep.
by scrolling down and then back up. So thank
Yeah,
you.
no problem.
Thank you for remembering.
The other thing Ms. Ellis pointed out, we were talking about the court rules, and I do want to point out that we have, again, I'm a federal court representative, so there are some differences between the federal and state courts, so we just want to be mindful of that too. And certainly I'm keenly aware of that, but it applies to more than just me, because there are folks who participate in a variety of different venues. I think that there's one more, but I think it will come up when we get to providers. So I'll hold my fire on that. Thank you.
Thank you. Not where it belongs, but I'll come back and I'll put it where it does belong. I'll find a better place for it. Let's put it that way. Okay, so here we are, definitions of firm and provider.
Alan, sorry to interrupt. Maddie Robertson has her hand up as well.
Oh, I'm sorry, Ms. Robertson.
Thank you. Going back to the list of who are included, non-judicial neutrals, I just wanted to make a comment that I think that could get very large quickly. There's tons of groups that aren't mentioned here, like restorative justice practitioners or conflict coaches. There just could be a real proliferation, and it might behoove us to be able to exclude groups so that this doesn't get unwieldy. We're going to have a hard enough time as it is finding standards that can cover all the various types of mediators and arbitrators and the different work that they do. So if we could find some way to exclude groups that as much as possible, I think that would be helpful.
Thank you.
Thanks.
And very quickly on that, Alan, I would love to put under the consider excluding types, the international arbitrators.
Here's mine. We're typing. Okay. Oh, Mr. Kelly.
The
Mr. Kelly,
the definition of mediation in 1115 is a functional one. And if you look at the comments, it specifically says could be somebody that's got a different title like ombuds. So when they are mediating, they'd be covered under the statute and defined as mediators. But when they are, for instance, surveying the hospital administration to see, do we have a systemic problem with a particular doctor or harassment or whatever, they're not mediators. So somehow we'd need to capture, at least with mediators, people that might not be called anything in particular, but are functioning as mediators. And that might be applicable to other neutrals as well. I don't know how many other neutrals that might be applicable to, but certainly mediators, it is applicable to.
thank you. Okay. Seeing no more hands, going down to the definitions of firm and provider, and this is something that we've already touched on a couple of times. Can we come back with those thoughts? Jones?
I would wonder if firm might refer to like law firms that have an ADR department and people who practice in both a litigator and a mediator capacity.
Mr. Petkin, thank you for coming back with your earlier thought.
Yes. So in terms of who is a provider, is, for example, my court program a provider, and we already have, standards that we are subject to ADR local rules and things like that. Would this purport to somehow supersede those, or would they be in harmony with them, or would they be exempted from them? So that's a secondary question, but who is a provider? First, is something like a court program a provider?
Yes, got that. Mr. Kelly.
I want to just suggest that we do our best to stick with the language in the statute. And I'm a practitioner, I'm an individual. I don't think a group of us could be called a practitioner. Provider could be an individual me, or it could be a group. A firm, I think, would have to be in some way a recognized firm, a company. I don't think a court program would be a firm. It seems to me that the language in the statute is appropriate to preserve. Thank you.
Thank you. And Mr. Palevsky.
Just for your benefit, the existing judicial council rules does have a definition of dispute resolution provider organization. I think it's 2G. It's pretty straightforward. It says if you're administering two or more neutrals. But it's more complicated than that, but there's a statutory definition already.
Yes, and as well as in the CPR Georgetown Commission standards, I believe. So thank you for that. Judge Pichon, I am a little bit concerned about time here. I think the agenda allows 5 more minutes for this discussion. Is that right?
Yes, actually, you have 4 more minutes.
4 more minutes. Okay.
You've done very well.
Yes, let's use them as quickly as we can. So certification of practitioners generally, Again, as I mentioned, is that overall or for specific ADR processes? Is it a general certification or certification for specific types of conflicts, family, real estate, et cetera? So those are, I think, are both issues that have been raised already in the conversation. Anything else in what's probably now 3 minutes left? And then I think we're going to need to come back to this discussion at a later meeting. I think it's very helpful that we're having the contributions we are. I think it'll serve the working group well down the road, but we can't do it all in one day, apparently. So quick thoughts about overall certification or certification for ADR processes. Other topics missing here? All right. Oh, Ms. Cruz.
Do we have a point on the application process? It might go here.
Okay, I trying to remember ahead. I know we have things about administration, but I'm not sure. I'll just make a note of it and we can come back and revisit it if we have it somewhere else. Well, listen, I think this is probably a good time to, if we can, adjourn this agenda item and return to it, if that's acceptable to the chair.
That sounds wonderful, and thank you so much for that. And I just want to commend everybody on the committee for the wonderful suggestions and offers of topics. This has been great. We appreciate all of this, and we really need it. That way we can make sure we cover everything and don't miss anything in the end. So now we'll go to the last item on the agenda, and that is item 2.6. And that is regarding subcommittees. We have decided to, for right now, to set up 4 subcommittees. I know that there are many that we will probably get to, but right now we wanted to start off with 4. And they are the baseline certifications for arbitrators, that's 1. The next is baseline certifications for mediators. The next is baseline certifications for other types of ADR practitioners. And the last relates to complaints and remedies. So I don't want you to think that we're going to leave anything out. This is just to start. And this is all of us in the beginning rolling up our sleeves. And this is where we thought would be a good place to begin our work. So if you are interested in serving on any of these subgroups, would you please email your interest to Angela Marloud by February 19th. And you already have her information, but we can send it out again. So would you express your interest in serving on any of these committees to Angela? And I'll say them again. It's baseline certification for arbitrators, baseline certifications for mediators, baseline certifications for all other types of ADR practitioners, and the last is a subcommittee on complaints and remedies. And yes, Ellen.
I'm sorry, Judge Bichon. I was just going to ask, I know you're continuing, maybe you're going to cover this, but I just wanted to assure everyone that the idea of the subcommittees is to have a smaller group kind of noodle some of these topics, but everything will come back to the full group, right, for further comments and for any ultimate decision of whether to approve it or not. And it may get sent back to the subgroup then.
Absolutely. Yes, everything will come to the main group, but in order to get the work done, we have to break down the numbers to subcommittees. Okay, any questions about that? Okay, well, I didn't say it at the beginning. Oh, okay, Dana.
I just had a question about what your expectations were in terms of any written information that comes from the subcommittees or reporting back or how that would work.
All right, I'm going to ask either Alan or Erica to address that.
I'm happy to, thank you. So the intent is that there will be either Alan or myself or both at these subgroup meetings. And our intent, we know that you have other work that is hopefully paid. And so our intent is for us to be doing most of the drafting. So we will be listening, writing, and ideally developing things for these subgroups and for the full working group to modify and tweak. But as far as the substantive work, obviously there will be, you know, a lot of reading and background and prep for these types of meetings, so that to the extent you aren't already, you are informed and can contribute to those subgroup meetings. But as far as the actual drafting and the homework, if you will, that will be prepared by staff.
And I'm sorry, one more question, and that is, will there be a chair? How does that work so that there's someone facilitating that, or will the staff person do so?
That's a great question. We at this time we're envisioning there would be a lead essentially for that subgroup that would kind of handle that. The reason that we're asking for people to indicate their preference is we recognize that probably everyone's going to be interested in each of these, at least for the baseline ones. And you recall that brief Bagley Keene overview I gave an hour or so, a couple hours ago. So we are going to, there will be people who don't unfortunately get to perhaps participate because we do have to reduce the numbers to do so. But again, you know, as Judge Pichon said, everyone will have an opportunity, or perhaps Alan, everyone will have an opportunity to engage and provide feedback and so forth. And, you know, the materials that we will be discussing and deliberating will be posted in advance of the meetings, just like the areas of focus were today. So you'll have a chance to review and you can send feedback in advance, ideally, or you can raise it at the meetings like was done.
Any other questions? Okay, well, thank you very much. Ron.
Will there be some opportunity to send something to a group we're not involved in that we might have a comment on through staff?
Like materials, or what are you envisioning here?
I have a particular point in that I'd like to make about the arbitration qualifications, but I'm not interested in being on the working group for that. How would that happen if I have a particular point I'd like to make to the working group?
With the permission of the chair, I'd wonder if you could do that now would be ideal, but if not, you could certainly send it to staff.
Would you like to do that now, Ron, or would you like to send it to staff?
I prefer to send it to staff and have it be thoughtful rather than off the cuff. Thank you.
Okay, all right, great. Anything else? And okay. Oh, yes, Jenna. You're muted.
I wanted to flag, we didn't make it to this page of the topics list today, page 6, where we talk about tiers or levels of certification, but it strikes me that there are some overarching considerations that might have a global impact on all 4 of the subcommittees or a number of them, and just had a question of what the plan is to handle that overlap.
Erica, do you want to take that, or do you want me to?
Why don't you, and then if there's anything that I think you'll have it covered, but.
Sure. I think part of the reason in having the 4 groups talking about baseline, we realize that there's going to be overlap between baseline and tiers. But it seems like to have the discussion begin with baseline, and there'll probably be some of the discussion may be, well, that shouldn't be baseline, that should be a higher tier. And so the idea was to later address tiers with the input from kind of establishing the baselines. And then I would think, I mean, we are anticipating a subgroup on tiers, and I think there'll be some back and forth about those. One of the things that there may be some common things about tiers that cut across the different ADR processes. So they apply to arbitration and mediation. And so, you know, the idea was to get those baseline first. That was the thinking.
Any other questions? Okay, well, it's been a pleasure, absolutely. And I wanted to tell you, it is an honor to serve as chair of this group. So thank you for your tremendous participation today. And with that, unless there's anything else that you wanted to say.
Just a huge thanks to the staff for all their hard work in putting together all the materials, since I found them personally very educational, and I know a lot of work goes into this from their perspective. So thank you. Big thanks to all the staff.
I'd like to second that, and it was especially helpful to have the materials in advance. That was wonderful.
Yes, I commend the staff also. They are wonderful to work with. All right, thank you all very much for being here, and we'll see you next time, and we'll get the work started in our subcommittees, and then we'll see us all together again. So with that, the meeting is adjourned. Thank you so much.
Thank you.
Bye, everyone.
Thank
Thank
you.
you.
Thank you.